Hello and welcome to the Minimum Competence episode for Tuesday, July 8th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, a lawsuit over vaccine policy, Trump sets sights on Hondurans and Nicaraguans, and my Bloomberg column on Maryland's troubled new tech tax. Let's remember, we shall not cease from exploration, and at the end of all of our exploring, we will arrive where we started and know the place for the first time, and read today's legal news. On this day in legal history, July 8th, 1777, the Vermont Republic adopted a constitution that became the first in what would eventually become the United States to abolish slavery. At the time, Vermont was not yet a state. It was an independent republic formed after declaring independence from both New York and British colonial rule. The new constitution, influenced by Enlightenment principles and revolutionary ideals, declared that, quote, no male person born in this country or brought from overseas ought to be held by law to serve any person as a servant, slave, or apprentice after the age of 21. This clause effectively outlawed slavery for adult men and set the groundwork for emancipation, although enforcement was inconsistent. Vermont's action was revolutionary, especially considering that slavery remained deeply entrenched in both the southern and northern American colonies. While other northern states like Pennsylvania and Massachusetts would later take steps toward abolition, Vermont's constitutional ban was a bold and early legal rebuke of human bondage. Despite its symbolic significance, the legal impact was somewhat limited. Vermont did not join the Union until 1791, and historical records indicate that some slavery-like practices may have persisted unofficially. Nevertheless, the 1777 Constitution established an early legal precedent for anti-slavery sentiment, showing how legal documents could be used to challenge institutional oppression. The language also hinted at the contradictions between American ideals of liberty and the reality of enslavement. Several major U.S. medical organizations filed a lawsuit on July 7th against Health and Human Services Secretary Robert F. Kennedy Jr. and the HHS itself, challenging recent changes to federal COVID-19 vaccine policy. The plaintiffs, including the American Academy of Pediatrics and the American College of Physicians, are seeking to overturn Kennedy's directive removing COVID-19 vaccines from the CDC's immunization schedules for children and pregnant women. They argue that the move poses an immediate threat to public health and undermines evidence-based medical policy. The complaint accuses Kennedy of dismantling the federally established vaccine framework that has historically saved millions of lives. Kennedy, a longtime vaccine skeptic, took control of HHS earlier this year and has taken steps to reshape vaccine policy. In addition to altering the immunization schedules, he also dismissed all 17 members of the CDC's Independent Vaccine Advisory Committee and replaced them with 7 individuals, some of whom have publicly opposed vaccination entirely. Medical groups contend that these actions are not grounded in science and place vulnerable populations at significant risk of preventable diseases. HHS has not yet commented on the lawsuit. The Biden administration had extended temporary protected status, or TPS, for Hondurans and Nicaraguans in 2023, citing lingering effects of Hurricane Mitch, political instability, and economic hardship. But on July 7th, the Department of Homeland Security under President Donald Trump announced it will end those protections effective September 6th of this year, impacting roughly 72,000 Hondurans and 4,000 Nicaraguans. TPS offers deportation relief and work permits to migrants from countries experiencing crisis, but Trump officials argue the program has been overused. Homeland Security Secretary Kristi Noem said both countries have recovered significantly, referencing tourism, real estate, and energy developments. Critics, including Democrats and migrant advocates, say ending TPS will uproot people who have legally lived and worked in the U.S. for decades and may force them to return to dangerous or unstable conditions. The Honduran deputy foreign minister acknowledged the decision wasn't country-specific but part of a broader rollback of TPS protections. Trump's administration has already targeted TPS designations for migrants from Venezuela, Haiti, Afghanistan, and Cameroon. Legal battles continue over the policy's rollback. While the Supreme Court recently upheld ending TPS for Venezuelans, a federal judge blocked the termination for Haitians just last week. And in my column for Bloomberg this week, I focus on Maryland's new 3% digital services tax, which took effect on July 1st. I argue that while the state's goal of modernizing its tax base is understandable, the execution creates more problems than it solves. Rather than taxing consumption, the standard and more efficient route, Maryland is taxing business inputs like data hosting and web services. This approach violates basic tax principles, potentially stifling investment and driving up operational costs for firms doing business in the state. The administrative burden is uniquely complex. Vendors must determine how much of each service is used in Maryland, secure pre-approval for calculation methods, and issue separate certificates per transaction. No other state requires this, which leaves businesses with a costly choice: build a Maryland-specific tax compliance system, risk penalties, or exit the market entirely. The true burden, then, is not just the 3% rate, but the compliance infrastructure that must be created from scratch. Ultimately, the tax may hurt the very businesses Maryland is counting on for economic growth. Consumers may face higher prices, companies may rout around the state, and the tax may collapse under its own administrative weight. I argue that the smarter path forward lies in multi-state coordination, where shared definitions and harmonized rules could make enforcement more efficient and less distortionary. Without collaboration, Maryland risks substituting short-term revenue for long-term competitiveness. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, genuine poetry can communicate before it is understood.